What's going on, everybody? Welcome back to the channel. Today I will be continuing on business trust, again specifically American Jurisprudence, volume 13, business trust. I know I took a little break. I got sidetracked from questions about passports and citizenship, so I made a couple videos on that. So hopefully you guys enjoy this also. Today will be part 7 on regulation from this chapter. So section 77, generally, the power of the states to regulate business trusts in various respects is settled. No unreasonable discrimination arises from a statute which regulates the activities of business trust as distinguished from traditional kinds of trust. And the right of a business trust to do business within a state as a legal entity may be conditioned upon its compliance with the laws governing such organizations. However, it has been held that the sale of its own shares by a business trust does not constitute doing business within the meaning of regulatory statutes. So this is key right here. It has been held that within the sale of its own shares, which is personal property, by the business trust does not constitute doing business within the meaning of regulatory statutes. I'm going to read those 7, 8, 9, and 10. Let's see what they give. Well, this is the supplement. It says, a Massachusetts business trust having a principal place of business in New York was held not to have engaged in activities within Florida sufficient to render it amendable to the filing requirements of Florida statutes requiring a business trust organized for the purpose of transacting business within the state to file a copy of the Declaration of Trust with the Department of State, where it appeared that an application for a loan was made in New York. All pertinent negotiations were carried on in the state of New York. The loan was closed in the state of New York. All documents, including the mortgage note, and the construction loan agreement, were executed in New York. The mortgage note specifically provided for the application of the laws of the state of New York, and the place of performance was in New York. But where the security for the loan was property located in Florida, and the mortgage, which was executed in the state of New York, was recorded in Florida. So that's the only thing that was, in this case at least. But nonetheless, it's all the contracts, all the activities were done in another state. Even more so that the laws that govern the contract itself, right? Or I think it's better to say not only just to govern, but to protect the parties involved, right? Or govern by the laws of New York, which has nothing to do with the creation of this instrument or the entity or the trust itself. This is actually a good case, Hemphill versus Orlov. That's footnote number 7. Yes, it has been said that a voluntary unincorporated association in the nature of a business trust do not fall within the class of natural rights, which is above the power of the legislator. As early as 1909, the legislature of Massachusetts required the trustees of a business trust to file copies of the trust instrument with the commissioner of corporations and with the clerk of the town or city of the usual place of business. And here, understand that this has nothing to do with federal. This is just intrastate commerce. That's key, important here. Intrastate commerce within the state. Pointing out that the business to be done by the business trust was of the character making it subject to regulation, just as in the case of corporations to which the regulatory law was principally directed. So again, key words here, was of the character making it subject to the regulation. Footnote 9, In a jurisdiction regarding certain types of business trust as being in the nature of a partnership or joint stock company, they may be required to comply for some purposes with the statutes relating to limited partnerships, which should be a given. And it's all depending on the construction of the trust itself. The applicability of business trust of statutes relating to carrying on business under a fictitious or assumed name is discussed elsewhere, and they have a different section for that. And it's section 18, which that should have been the first video. Which, again, I apologize, still I have not remade the first video. It's basically an audio video because I forgot to share screen. Section 78, under statutes relating to corporations generally. Business trusts have frequently been held to be subject to statutory regulations of corporations and to provisions aimed primarily at corporations. A state has the power to include such trusts within the definition of corporations. Accordingly, business trusts have been held to be corporations within the meaning of statutes requiring corporations to file reports and pay fees. They have been regulated as corporations under general constitutional provisions that the term corporation should include all associations and joint stock companies having powers and privileges not possessed by individual or partnerships. And by virtue of constitutional and statutory provisions, the term corporation should be construed to include all associations and joint stock companies having any powers or privileges of corporations not possessed by individuals or co-partnerships. However, a business trust has been held not to be a corporation within the meaning of a statute regulating corporations and defining the term to include all joint stock companies or associations having any powers or privileges not possessed by individuals or partnerships. And the key words here you should be paying attention to, right, is they keep calling them associations. They keep calling them something else, right? They'll say that a business trust is held to be this, but they're calling it that for a specific reason. And that is almost always because of the trust indenture itself, how it's functioning, how it's structured. It's not a trust in that case, in that specific circumstance or context. It's acting as a corporation. So depending on the activity and depending from that activity how you're structured, well, there you go. That's how you're going to get hit. A business trust has been held to have the right to do business as a building and loan association without becoming incorporated under a statute expressly authorizing any unincorporated association of individuals to carry on such business, subject to certain regulations. That's regulations, not requiring incorporation or licensure. Another thing that I want you to understand, right? Building and loan companies, right? They're not banks. They're there to loan money. That the definition of banking as provided in the Constitution as a delegated power to Congress does not include loaning money, borrowing money, or whatever else. It only applies to, how can I say this? The creation of demand notes for the purposes of circulating as currency. That's what banking is in the system. Everything else is a power that still is reserved by the people. I hope you guys understand that. And a statutory prohibition against the operation of a cemetery for profit by a corporation has been held ineffective to bar a business trust from doing so. So here, a statute, right, from probably some state, right, prohibited a corporation from running a cemetery for profit. They could do it probably for non-profit, but in this case for profit. It can't be used against a business trust because a corporation is literally a franchise of that state that it was incorporated by. Under a statute expressly authorizing a trust to acquire, hold, and deal in real estate and to carry on any lawful business, and generally to do any lawful act in relation to the trust, to the trust property, which an individual owning such property absolutely might do. Further, it has been held that a business trust does not come within the prohibition of a statute imposing penalties on corporations for holding real estate in the manner forbidden by the state constitution. Those are all specific criteria. Let's see what persons who conveyed land to a business trust, receiving in consideration of the transfer shares in the trust which are not, as a matter of judicial determination, valueless, and who permit the trust to enter upon the land and spend considerable sums of money in its development, have been held estopped to subsequently assert the invalidity of their deed on the alleged ground that the trust was in fact a corporation and had failed to comply with the statutes requiring the granting of a certificate of incorporation before. This is a good case. I'm pretty sure I know what that case is. Oh, actually, no, I don't. Sounds similar to another one. I don't remember the name, but I know if I see it, I'll know it. But I know this one ain't it. Right? Wherein the court pointed out that if the organization was a corporation in law, the grantors dealt with it as such, and if the common law trust represented by trustees, the grantors dealt with individuals sui juris, and that in either case they would be estopped. Let's read the supplement. Case authority. Under a Business Trust Act incorporating a provision that business trust should be subject to all applicable provisions of law governing domestic and foreign corporations in many specific particulars, except to the extent that such corporation provisions were inconsistent with the specific provisions of the Business Trust Act. A statute excusing a foreign corporation from qualifying to do business within the state if its only activity in the state was the lending of money and dealing in security interest also exempted from the registration a foreign business trust whose only activity within the state was the making of secured loans. Footnote 12, this, like I said, Hemphill versus Orloff, as stated by the court, whether a given association is called a corporation, partnership, or trust is not the essential factor in determining the powers of a state concerning it. The real nature of the organization must be considered. If clothed in the ordinary functions and attributes of a corporation, it is subject to similar treatment. And this is what I've been saying, right? The name don't mean shit. That's just form. It's the structure, the powers that you confer, the powers that you withheld as a grantor, the powers that the beneficiary have, and all that stuff. Who has control, right? Those things all have to be considered, right? If clothed in the ordinary functions, and attributes of a corporation, it will be treated as such. I know this case. I read that case. I can't recall it. Involving regulations concerning right of corporations to do business within a state. Business trusts have, among other powers and privileges not possessed by individuals or partnerships, those of continuous existence and exemption from personal liability. See, now this right here, this is one of the principles of ordinary trust law, right? Is that the trustee is liable. So if that is a characteristic of a trust, and you give limited liability to a trustee and the beneficiaries and so forth, right? Then what is it that you're doing? You just gave it an attribute that does not belong to trust. Now, that alone does not make it a corporation or an association, but it is one that gets piled on by others that you might have. And those 2, 3, or 4 combined, depending on what state you're in, right? That will change the circumstance of that structure. They enjoy practically all the advantages of ordinary corporations, and no reason is apparent why they should not be subjected to the same obligations and regulations. And that's based on what? powers and privileges not possessed by individuals. And in this case, they say partnerships too, but for us, for me at least, individuals. Section 79. Under statutes relating to foreign corporations, a business trust seeking to carry on business in a state other than that in which it was organized as an entity clothed with particular rights and privileges not possessed by individuals or partnerships may be subjected to the conditions such as the procurement of a certificate of authority, which are usually imposed on foreign corporations, asking for permission. Treating a foreign business trust as a foreign corporation for the purpose of such regulations does not violate any constitutional rights of the trust or of the members thereof. Specifically, such legislation does not violate the Privileges and Immunities Clause of the United States Constitution. Furthermore, the fact that by the Constitution and statutes of the state where the trust was organized, it would not be deemed a corporation has been held to be without significance in determining the applicability to the trust of local statutes and constitutional provisions relating to foreign corporations. And we'll go to this one right here, number 3. And they give you the case again, Hempleff versus Orloff. Declaring a business trust to be a corporation does not unconstitutionally abridge the privileges and immunities of any citizen or deprive anyone of property without due process of law or of the equal protection of the laws. A business trust organized in another state has been held to be a foreign corporation and subject to the regulations imposed by statute upon foreign corporations doing business in that state, and also subject to the same penalties as foreign corporations for failure to observe such regulations. However, the view has been expressed that since a statute requiring foreign corporations to comply with certain regulations and prohibiting them from maintaining actions unless they have done so is rigorous, if not penal in character, it will not be construed as to be applicable to a business trust unless the intention is to apply it is clearly manifested in the statute. Moreover, some courts have taken the position that business trusts are not subject to statutory regulations of foreign corporations, even under a definition of the term corporation as including all joint stock companies or associations having any powers or privileges not possessed by individuals or partnerships. I think one thing I should mention within these last 3 sections that I read, right? Because a lot of them seem like as they are opposite or they counterintuitive of each other, right? Like they are, one says one thing and the other says the opposite, right? It is 100% dependent on the state that you're in. Say, for example, in one state, say Illinois, right? You might have to give notice to the beneficiary that you're creating a trust on his behalf. But say in California, you don't. Now, one is a requirement that they need to be told and the other one isn't. That is completely based on the statutes regulating these types of entities, any trust, not just business trust. It is important to understand. And applying that principle, meaning the jurisdiction of where this is being created at, not by statute. This is created by your hand, right? Your right to contract, right? But the regulation of the concept of what you're trying to accomplish, the context, the business, you know what I'm saying? The overall structure. However, the view has been expressed that since a statute requiring foreign corporations to comply with certain regulations and prohibiting them from maintaining actions unless they have done so is rigorous. I already read that. Moreover, some courts have taken the position that business trusts are not statutory. I think I read all these, right? All right, sorry. Let's go with footnote number 5. Again, Hemphill versus Orloff. And this is why you see in all these sections, you're going to have different cases from different states. They're giving you case law of what has been decided in that case under a specific topic, right? In this case, foreign corporations. Okay, well, Michigan held this. Well, Illinois held it this way. California held it this way. Delaware held it this way, and so forth. You know, it's dependent on the statutes and constitution over there on what, to be honest, the proper way to say it, on what the people have allowed their local government to do, because the people have determined, right, by their voting, what they approve of. Ideally, maybe not today because people are stupid, right? But in the past, when people paid attention to their government and to laws, that is how it was structured and created. It says, where a constitutional provision defined the term corporation as including all associations and joint stock companies having any of the powers or privileges of corporations not possessed by individuals or partnerships, and the statute providing the term corporation should include all associations, partnerships, associates, and joint stock companies having any of the powers or privileges of corporations not possessed by individuals or partnerships under whatever term or designation they might be defined and known in the state where organized. It was stated in Michigan Trust versus Herplosheimer that the case of Hemphill versus Orloff, stripped of surplus verbiage, merely holds that a common law trust organized in another state was amendable to a statute regulating the right of foreign corporations to do business in that state under the statutory definition of the term corporations as used in the statute. In Harris versus United States Mexico Oil Company, it was held that a business trust was subject to service of process by publication under a statute providing for such service upon foreign corporations in view of a constitutional definition of the term corporation as including all associations and joint stock companies having powers and privileges not possessed by individuals and partnerships, involving this ability to sue on causes of action arising of unauthorized business. That's what that case was about. The trustees did something that was not in the trust indenture, and they were taken to court by that. Footnote 9, wherein the court in holding that a business trust organized in another state was not required to comply with a local statute relating to foreign corporations, which defined the term corporation as including all joint stock companies or associations have any powers or privileges not possessed by individuals or partnerships, took the position that the parties by contract could not confer upon themselves any rights or privileges not possessed by individuals or partnership. And again, just look at the words they're using. Corporation as including joint stock companies and associations. If you're trying to create one of these entities, what is it that you're supposed to do? Don't be one of these things. You have to avoid what are the characteristics of these things. What makes up a corporation? What makes up a partnership? What makes up an association? And so forth. So this is section 80 under Blue Sky Laws and Security Acts. So if you guys are on my Telegram, in the pin section, I have a law review that I highly recommend people read, and it's about the Blue Sky Laws. Statutes regulating the issuance of sale of securities, commonly known as Blue Sky Laws, are generally construed as applying to Massachusetts or business trusts and as requiring such organizations to comply therewith as a condition of the right to sell their shares. Some security acts or Blue Sky Laws are specifically made applicable to business trust, and particular language of other acts has been construed to include business trust. Thus, the shares of a business trust have been held subject to regulation under blue sky laws applicable in terms to an investment company or an issuer of securities, or generally to any person, firm, association, company, or corporation selling securities or offering them for sale. So what's missing in this whole section is being offered in the public. They're not saying anything in terms of privately sale, which a little bit ago in another section, it said otherwise. A blue sky law applying to business trust and accepting from its operation testamentary trust and trust created by judicial decree is not, for that reason, unconstitutionally discriminatory. Such a statute construed by the court as applying to a business trust is not therefore an unconstitutional abridgment of the right to their own property and to contract freely with reference thereto. Under a blue sky law providing for the licensing of investment companies and dealers by the bank commissioner, a Massachusetts or business trust organized in another state has been held to be entitled to a license, and the refusal of a commissioner to issue the license on the ground that the law did not authorize such an organization or recognize the legal existence thereof was held to be erroneous. However, a different view has been taken in a jurisdiction in which a business trust is regarded as a corporation. And look at, and here they're telling you, a different view in another jurisdiction, right? This is why you need to read your own state statutes on trust law and so forth. I highly recommend you go to your law library, not only get American jurisprudence on the topic that you're looking for, but get your state's version too. Ours is Illinois is called Illinois Jurisprudence. I guarantee every state has something similar. Under particular circumstances or with regard to certain transactions, blue sky provisions may not apply to business trust. Thus, in view of another statute requiring a permit from the supervisor of a building and loan association after his approval of the plan of business as a condition of the right of an unincorporated association to carry on the business of a building and loan association, a business trust proposing to engage in such business was held not to be required to comply with the blue sky law relating to corporations generally. And here the supplement says on the same side of the table is Investment Company Act rule. I don't know what that is. That's a security regulation right here. Footnote 10. Under statute defining dealer as one engaged in selling stock certificates, membership certificates, or securities of whatever kind or character, and provided that any person, partnership, corporation, or association offering its own securities for sale should be considered a dealer within the meaning of the act. We think the courts are practically unanimous in holding the Massachusetts Trust amendable to the requirement and exactions, which is taxes, of the above statutes, commonly known as the Blue Sky Laws. The aim of the courts has been to carry out the manifest intention of the statutes, of preventing the public from being imposed upon by questionable and unsound financial schemes of fortune dreamers and dishonest promoters, and to reach all get rich quick schemes offering to the general public their stocks and securities under whatever name they may choose to act. And here they are. They finally said it, right? From preventing the public from being imposed upon the questionable character and unsound schemes, right? Offering to the general public their stocks and securities. And this is the key word, general public. For instance, right, what's the difference between Costco and Walmart? One is membership, meaning you sign a contract that gives you rights and takes away rights while you're in their store. When you enter Walmart, it's not like that. You are protected 100% by the general public laws that protect you, because that store is open to the public, where Walmart or Costco is not. The injury and opportunity for imposition are no less when the purveyor of such stocks and securities is a trust of the Massachusetts type than when it is a corporation, co-partnership, company, or association. Such a trust certainly falls within the evil intended by the lawmakers to be prevented as much as any other organization engaged in the business of selling stocks and securities to the public. Because of a supposition of such organizations were not subject to the blue sky laws, the adoption of such statutes in several states stimulated the creation of Massachusetts Trust. This right here is a good case. This is the one I spoke of in the Telegram group, Kinross versus Cooper. And they don't mention it here, which is shocking, right? The other one also. Because you have two. You have Evans versus Freeman, which is the terminology used for what is considered domestic under a federal act, right? And then the other one, Kinross, is the terminology for what is considered domestic for, at least in this case, the state of Illinois. So holding without determining whether a business trust was technically a corporation, voluntary association, investment company, common law trust, joint venture, or profit-sharing scheme. The statute defining investment companies such as was entitled to the license as every person, corporation, co-partnership, company, or association organized in the state or elsewhere, whether incorporated or unincorporated, which should sell or negotiate for the sale of any contract, stocks, bonds, or other securities issued by the such person, corporation, or association. And this is important too, right? They're entitled to a license. But in this scenario right here, the business trust is actually stating that they are functioning in a corporate capacity, because this statute specifically applies to these organizations. But just because it applies to them doesn't mean that you cannot be an investment trust if you are a true business trust, meaning you don't fall under corporation, association, or whatever. You have the right to do whatever, carry on any other business that you want to, as long as it doesn't belong to the government, so to speak, right? Like banking. You cannot do banking that expressly, banking of the type that was expressly conferred to Congress. You cannot do that without permission from them. I hope you guys understand that. Right? You cannot do banking without permission from the owner of that property, because that's what that is. We gave it up to them. It belongs to them. They have plenary power over that context, that power, that activity. On the ground that a business trust came within the constitutional definition of corporation, the Washington court has upheld the act of the Secretary of State in refusing to consider the application of a business trust for the permit to sell its securities and shares in that state, since the trustees were assuming corporate powers without complying with the laws relating to corporations, and the organization was illegal and had no legal standing because they were seen as a corporation. So if they're a corporation, what do you have to do? You have to incorporate, you have to register, you have to get licensed, you have to do all these things because you are a franchise of, you are considered a franchise of that state. The shares of a common law trust formed by the members of the club to save the property of the club from the mortgage foreclosure, which shares were subscribed by the members of the club, were held to come within the exemption of the blue sky law of securities of a corporation when sold or distributed by it among its stockholders without the payment of any commission or expenses to agents, solicitors, or brokers, and without incurring any liability for expenses whatsoever in connection with the distribution thereof. They save their company. It seems that under the California statute discussed in Bernison versus Fish, no permit is necessary for the issuance of certificates to the original founders of the trust as compensation for property conveyed to the trust. Section 81, consequences of and who may assert violation of statute. A trustee's sale of shares in a business trust without a permit from the Corporation Commissioner as required by the State Securities Act under circumstances amounting to fraud has been held to be absolutely void. However, as regards to the rights of a bona fide purchaser for value of real property from the trustees, the failure of the trust to obtain a permit required by the Blue Sky laws does not invalidate the conveyance to the trustees or the conveyance by them. While creditors of a business trust may attack the validity of securities issued by it in violation of the Blue Sky law, mere strangers may not. A person contracting for shares of such a trust can raise the question of the failure of the trust to comply with the Blue Sky law, the principle that the ultra vires transactions of corporations may be questioned by the state only not being applicable in such case. Such a trust cannot recover on a negotiable instrument given for the purchase price of shares sold in violation of the Blue Sky law, and a person purchasing shares from a trust which sold them in violation of the Blue Sky law may recover back the purchase price paid therefor. In such a case, the subscriber is not in peri delicto. I forgot what this means. I think basically ignorant, right? Why ain't you here? A Latin phrase commonly used in tort and contract law, which means in equal fault, right? Let's see what this is. This doctrine states that there is a bar to a plaintiff's recovery of damages for a wrong the plaintiff participated in and serves as an equitable defense. And the defense that the purchaser of the shares was in peri delicto is not available against an action or counterclaim for the purchase price of shares illegally sold, since the Blue Sky laws are intended for the special protection of such persons. Footnote 3. A defendant in an action by a foreign business trust in order to rely upon the failure of the trust to comply with the Blue Sky law of the state of its origin must plead the statute. Since the contract by the trust to sell shares without complying with the statute was illegal and in violation of law, it was held that it was incapable of ratification and that the purchaser was not estopped to set up the violation of law as a defense to an action by the trust on the note given for the purchase price of shares. A check given for the purchase price of an interest in shares of a business trust which has failed to incorporate before engaging in business as required under mandatory constitutional provisions defining corporations as inclusive of all associations having powers or privileges of corporations not possessed by individuals or co-partnerships is given for an illegal consideration, and payment cannot be enforced as between the parties to the instrument, in which the statute made an act of selling securities without complying with the statute a misdemeanor, but impose no penalty upon one purchasing such securities. Section 82, Federal Securities Acts. The Federal Securities Acts of 1939 and other related federal legislation clearly include business trusts within their operation. Thus, the Federal Securities Act of 1933 specifically includes within its provisions trust in which the beneficial interests are evidenced by securities. And it is clear that shares in a business trust are securities within the meaning of this federal act. The Securities and Exchange Commission is not precluded from exercising the power conferred upon it by statute to set up terms and to condition its approval to a petition for delisting a security from an exchange merely because such terms would give the shareholders of a business trust the right to vote upon a matter as to which they have no voting rights under the instrument of the trust. The supplement, and they tell you, I don't know how they're saying this, section 12 and through 15, or 12 and 15 of United States Code, section 80, has been redesignated as section 80 and number 36 instead of 35. Here, footnote 9 is telling you to go look at United States Code, Title 15, Section 77. And that's that one. Footnote 10, see the Trust Indenture Act of 1939, which is 15 U.S.C. Section 77 AAA. The Federal Securities Savings Act of 1934, which is same title, Section 78. The Public Utility Holding Company Act 1935, Section 79. And the Investment Companies and Advisors Act, Section 80. That was for footnote 9. Sorry, that was footnote 10. And it says the Federal Securities Act 1933, which is 9, and other related federal legislation clearly includes business trusts within their operation. I would want to read these. Not really I would say read the statute too, but in all honesty, go read the act itself. More so read the statutes at large of this act to find out truly what the interpretation is of what a business trust is, right? If they're calling it an association. If it has the attributes of a corporation and association. Footnote 11. Generally, as to the Federal Securities Act, see Securities Regulation. For similar definitions in the related acts mentioned above, see Section 77 CCC of Title 15, 78C, 79B, 80A. See Securities Exchange Commission is a court case, a DC federal supplement, and it was affirmed, reversed on other grounds. So it was affirmed on this application, but reversed on some other technicality. So the affirmed part still is being upheld, at least up to today. All right, well, that's it for now. Until the next video. The next video will be, of course, part 8, which will be taxation. I don't know if it will be 1 or 2 videos, but we'll see. To add to this is for sure read the Blue Sky Laws, right? The law review. There's a couple of them. I think there's at least 2 of them on my Telegram page. But for sure, read the acts themselves. Here the information is right here. Don't neglect this. That is, of course, if you are choosing to sell shares, right? If you're not, and all it is you're transferring shares for the exchange of property for some benefit, right? For some person to benefit for it, then that's not an issue. But if you're looking to make some type of income, right, by selling the shares, right, like an investment trust or something like that, that's different. You want to make sure you want to comply to the best that you can, if it even is applicable to you. But at the same time, that's most of this stuff are public acts. They are meant for the sale of such shares in the public. All right, well, Have a good one, guys, and please like and subscribe to the Butterfly channel, the Butterfly Monkey channel, and see you on the next one.